Good evening, welcome everybody. My name is Eduardo Estordera. I'm the director of the program of Law and Economics. I'm in charge today of our seminar of Law, Economics, and Regulation. Today we have the pleasure and the honor to have with us Professor Peter Lewisch. Peter is a full professor of criminal law and director of the Center of Law and Economics at the University of Vienna. For us, it's a real honor and a pleasure to have with us Peter. Peter already lectured at Ditela about 2 or 3 years ago, and I had the pleasure to meet Peter during a visit to UCLA years ago. Well, the mechanisms is going to be as always, no? Peter is going to lecture for about 30 or 40 minutes. Meanwhile, you can make your question using the chat, or you can wait until Peter finishes, and then we can engage in a discussion in a time. So, Peter, thank you very much for being with us today.
Thank you. The pleasure is all mine. Thank you, Eduardo, for this warm words of welcome. I would have loved to say it's a pleasure being back in Buenos Aires, but I only tune in from Austria over the ocean. So my best greetings from good old Europe to all you. And it's indeed a pleasure and an honor to have the opportunity to address you here with I think it's a current topic of law and economics. Okay, so I will right. This works, okay? You can see it? Yeah, I guess. So I will start with my presentation right away. Okay, beyond preponderance of evidence, and I have to say the best thing, I guess, is the title. The second best going to come right now. So as a law and economics paper, if you go to the smart American books in law and economics covering standards of proof, you will see that the American scholars are quite proud of applying law and economics thinkings to these questions, and they come up and defend the difference of American law between preponderance of evidence as the relevant standard in civil procedure, whereas it's beyond reasonable doubt in criminal cases, and defend it as an efficient institutional differentiation and solution, beyond reasonable doubt being the highest standard in criminal cases, if you will, on the basis of the Blackstonian reasoning, it's better than 10 guilty people go free than 1 innocent person is convicted. However, this literature does not fully acknowledge or appreciate, perhaps, that in other parts of the world, notably in Europe, but also in all the countries with the continental legal system, this distinction does not exist in this way, but it's rather one standard, the personal conviction of the judge, a clear evidence, clear personal conviction in terms of practical certainty of life, clear and convincing evidence that governs either field. So what's going on? Have we overlooked something? And I like this general approach. So the law is different in different countries. Economics is the same. So economics should be able to contribute a little bit to differences and identities of the law around the world. So if we look behind the surface of the national laws, so what is my take here? And it is we have to analyze the pertinent procedural rules to the extent to which they are incentivized in terms of backward induction. So what do the highest courts tell us about standards of proof, and how does this work into the calculus of the judges of first instance? Having said this, I will present you some of my main ideas here. I think law and economics analysis is helpful, but it settles the horse from the wrong side. A law economics analysis starts taking the rules of proof as given and assuming that the judges will apply these standards of proof quite literally. They will do what they are ordered by the law, and they are able to do this. And other courts, higher courts, are able, implicitly assumed, to check the correct application. But I would submit that this is incorrect, this approach. Instead, what will judges really do? They will anticipate what the highest courts can do in terms of checking. And if we look what's going on, what is the standard of proof? It is in the mind of the judge. The mind of the judge, he appreciates, evaluates the evidence, and he comes up with, okay, I believe that this witness is lying, or I believe that the other witness is lying. I believe that the defendant is telling the truth or not. And this mental process is actually not controllable by the instance. And because it's not controllable as such, the instance can only higher, the Court of Appeals can only intervene if it's a clear gross error, because otherwise no reason to, no ground to intervene. And therefore, so the standards are blurred. They cannot be checked in that sense, and it's more a nudge than an incentive. And legal ethos, judicial ethos, does play a role in all this. And this applies to the law in general, and it applies to competition law in particular. Having said this, so what is this paper about, this little presentation? So I'm interested in how the law deals with the enforcement of standards of proof, with the institutional rules that have been brought about, given that the standard of proof as such is hardly controllable. We'll see that there are different ways how the institutions, how the laws react to these issues, and we'll discuss them as we go along. Just as a starting point, the topic is complex and not to be missed. Proof is not only proof in the narrow procedural standards, but of course it's dependent on what is to be proven under substantive law. And the positions of the parties altogether depend on the overall assessment of substantive and procedural laws. Moreover, not to be overlooked, in many areas of the law, special rules of evidence apply. Still, what I've just outlined before, the basic difference in the US between preponderance of evidence for civil and beyond reasonable doubt for criminal cases. Now, in the continental legal system, it is originally the personal conviction of the judge. The French, the conviction intime, it's a French standard. But it's not only, so originally it was my inner conviction, but then it was transformed into it must be communicable. It's not only my inner conviction, it must be communicable to the others and communicable on the basis of the evidence collected in the trial. And then practical security of life, so a relatively high standard that applies both for criminal and civil cases. Is the benefit of doubt important, or is it not so important? Well, as a legal rule, not really, because judges rarely are in doubt. So, and here it comes. My take here is that the normative standard is not controllable. So the law, the institutions develop different tools whereby they check the standard and its application. So the decisive aspects are: who is the decision maker, under which standard of controllability does he operate? Therefore, what are the incentives applicable to him? And if the control is loose, the actual application of the standard may deviate from the legal concept. Okay, so what do judges do? They decide cases, they do not decide cases, and the procedural task is just to get it just speedy and inexpensive. Now, there are different ways of checking on decisions. And I was saying that it's hardly controllable what is in the mind. The institutions are different. The first thing is control at the level where the decision occurs. And the original idea by the law is, okay, have panels, have a group of judges together, and they check each other in a discussion, and they share, they challenge the concepts, the evaluation, and by this, implicitly already in this first level decision, the law tries to bring about a decent and reasonable result. So that may be a panel of professional judges and a panel of lay judges, namely a jury. Okay, so there is no control from the outside, but control from the inner discussion. The first thing, how the law deals with this issue. The second is what I call a quasi appeal. So two separate bodies still on the same level, checking each other. And again, the jury system, note that in the United States, juries are also applied for civil cases. The jury system is a good example. So in the US, the judge and the jury must concur for there to be a conviction. So the judge may oppose either at the beginning or at the end of the trial a guilty verdict. And if he does not concur, if he does oppose, there is no guilty verdict. Okay, so it's the so-called double veto of the trial judge. The judge may originally order a judgment of acquittal, right at the beginning, say there is not sufficient evidence demonstrating guilt, or also after the trial, as one says, he is the 13th juror. He may veto a guilty verdict by the jury on the basis that he considers this evidence not sufficient, right? So by splitting the competencies between two separate bodies on the same level to check each other, the law implicitly and to some extent explicitly brings in an institution that controls the correct application of the standard of proof. This is on the first level. So panels of judges or split competencies between separate sub-bodies on the same level. But it goes on, how does the law deal with, saying, appeals, with a second layer, a judicial layer, that controls the application of the standard of proof? And here we'll see it's judicium novum, a substitution of the decision of the first court by the second court. It's a formal legal control in terms of causation, and sometimes, but very rarely, a real reassessment of the evidence. Okay, what do I mean? And this is actually, it's a little bit a technical point, but it's a point that is often overlooked by lawyers even. So many legal systems do have in one form or another an appeal system that is functioning as follows. It is, if you appeal upwards, the Court of Appeals decides afresh. The Court of Appeals renders a new judgment. What does this mean? It means that the Court of Appeals does not control the application of the standard of proof by the first instance, but the Court of Appeals makes its own judgment and evaluation. There is no control because control is so difficult. If you appeal under this procedural regime, the decision of the Court of First Instance vanishes. It goes away, and the Court of Second Instance does not look to this decision by the first court, the Court of First Instance, but makes its own fresh, independent, new assessment of the evidence. Okay, so there is no control at all. The application of the standard of proof by the first instance is not checked. Instead, the Court of Second Instance decides afresh. This is used in the US, this is used in some cases in Austria, and this is used, the system is used in most legal systems in one or another way. So again, no check of the standard of proof, but decision afresh, judicium novum. Okay, the second way how institutions deal with that is annulment or causation, legal review. Exists in most legal systems in one or another way. In particular in the French, Latin, Italian world. So the last instance, or sometimes the second instance already, is a legal review. It's a system of legal control, and only errors of law are relevant. So the system is, the trial is over in the first instance, no further hearing of witnesses in the second instance, but the second instance checks the correct application of the procedural law in the first instance, right? So if you have, say, two witnesses, and one witness says is guilty, the other witness says is innocent, okay? And then the court in the instance, in a causation procedure, would only look whether the material is correctly put together and evaluated formally, but not in substance. So if the court of first instance neglects one witness and deals only with the statements by one witness, leaving aside the other, this is formally incorrect. It's formally incorrect because the formal correctness would require both witness statements to be seen together and then to be evaluated. The process of evaluation as such does not come into focus. So if the court of first instance says, okay, we have this witness statement, we have that witness statement, and I come to the conclusion that this witness is lying and this witness says the truth, no further control or check in a causation procedure being possible. If, however, the court of first instance says, okay, we have one interesting witness statement, and he says he's guilty, therefore he's guilty, that would be formally incorrect because the procedure is insufficient in that sense, because we had two results and only one is evaluated in the process. Right, so it's a formal control. It does not look into the evaluation process itself. And again, we see, because it is so difficult to look into the brain of the judges, this formal causation procedure is seen in most legal systems somewhere to be used. Okay, but then we have also in most legal systems a review of factual and legal questions, and I would add at least on the paper, in the sense that the court of higher instance, if he considers the evaluation of the facts unreasonable by the lower court, the court of higher instance can in some way or another reassess the evidence. Okay, and it's a complex thing, and we're talking about different systems all over the world, but the bottom line really is, of all the legal systems, the bottom line is that courts of appeals rarely reassess the evidence. Rather, they support, they uphold the assessment of the lower instance. Second, that they do this only in cases of gross error, not of debatable things. And in many legal systems, it's not allowed to reassess on the paper, say on the file of the protocols of the first instance, but then the court must really rehear the evidence itself. The basic, I think, basic finding is practically in all legal systems, the de facto control is reduced to cases of gross error, clear and how to say, clear and close to evident errors, so that the higher court may intervene. This is true in Germany and in Austria, true in the United States, and true actually in all countries that I know of, legal systems that I know of, or with representatives of the legal system I've spoken to. Consequences, therefore, are the control of standards of proof are very soft. They leave wide discretion to the court of first instance. The court, it must be clearly erroneous, and the courts of first instance realize that it's difficult, so that they know they have a lot of power in the assessment of cases and evidence. There's hardly any real incentive if they, as an experienced judge could do, if they take the right wording. It's hardly possible for a higher court to crack the nut, to reassess the evidence, unless it's a clear error. What does this mean, actually? What does this mean? If we have a standard, and we'll address this right at the end also, if we have a very high standard and it cannot be controlled as such, the judge may reduce the real application in his mind of the standard and go down. And it will not be controllable by the higher instance unless it approaches the area of a clear and present, the area of a clear and present error. Okay, so because of that, legal ethics, judicial ethics do play an important role. Okay. Having said this, so what does it mean that we have different standards of proof here? Let me go to this little matrix here. Funny enough, when I presented these ideas for the first time, Francesco Parisi, famous law and economics scholar, was present. Fortunately, he agreed in a discussion with my thoughts, basically, and then mentioned that he had also a paper out where he tried, on the basis of case law, to quantify what reasonable doubt meant or means in the United States. And without, it's an article in its own splendor, but without going into details, just that you see what reasonable doubt means in different states: 83, 50, 50, 83, 90, 50, 90, 50, 50, 50, 50, 90, 50, 98, 1998, 50, Supreme Court, 50%. So this, of course, is not rocket science, but it shows that if you try to quantify the standard, very different things come out. And of course, it is the standard of the highest court that's where the music plays. Consequences of that. It's not an incentivized rule, it's rather a nudge. Judicial ethics and judicial training play a role. But let me add, there has been experimental findings in the sense that different standards of proof do have an effect on how people decide cases. So if we in an experiment are told to apply a standard of, say, 90% or a standard of 60%, the outcome will be different. It will not be exactly 90 and 60, but there is a certain influence by the standard of proof. So it does make sense to verbalize the standard of proof in proceedings. One issue, to verbalize them and to influence people in a certain direction. But still, although it has a certain influence, the correct application, and this is my point, the correct application is hardly hardly controllable. And because it is hardly controllable, that's why the legal systems have developed these rich systems of panels, juries, quasi appeals in the first instance, of judicium novum decision, where there is no real control, but a decision afresh by the instance, by review in terms of nullity, where the correct application again is not an issue, but the violation of formal rules, formal procedural rules of evidence is the decisive factor. And only in some cases, the unreasonable decision can be picked up by the court of instance. And in these cases, as I've tried to argue, only gross error worldwide and gross error taken up. Okay, basically, I'm at the end. That's all, folks, and I'm looking forward to your questions. Thank you.
Peter, thank you very much. Thank you very much. Well, Peter, thank you very much, Peter. Now, if anybody wants to ask a question or introduce a discussion, is invited to do so.
Horacio. I say somewhere, or shall I go to the chat?
Yes,
Do you tune in?
Use the chat or you can ask, no? Horacio. Horacio, how are you doing,
Yeah.
Horacio? So nice to see you.
I can't see nor hear anything.
Horacio, I think that you have to, I think that because of the system, you have to write. Yes, you have to use the chat for the question. I'm very sorry, it's a limitation of the, no?
I mean, you can speak up if you turn on the microphone. If you're allowed to do this.
No, Horacio
No.
have to use the chat for the questions.
Okay.
I'm sorry, Horacio. It is how is the structure, the mechanism of the seminar.
So I cannot see a question here on my chat screen. Okay, my question.
Can you read
Yeah,
it,
okay, I see. Okay,
Peter, or?
Yeah. If a rule is incentivized, so some consequences, positive or negative consequences, will follow from obeying or not obeying the rule. The incentivized part of the rule, in my take, is only to the extremes. In between, because the application is not controllable, actually, it is the discretion of the judge, what he really makes out of it. And therefore, in that segment, it's how he applies the standard of proof, uncontrollable by the instance. Now, having said this, still the law says something. It addresses the judge. It addresses the judge with saying you should convict only if it's beyond reasonable doubt. You shall hold accountable this enterprise for a violation of the competition law under this and that standard. Given a normative standard, knowing that there is no control. And in that sense, because it's in that part, it's not incentivized, it's more, say, a nudge, a hint, a behavioral hint, even though in that area, nobody will be able to check. But the 10 Commandments is a good question. So the 10 Commandments taken literally, in the secular world, are nudges in the secular world. In the theological world, they're not nudges, but they are incentivized with, as you know, the final judgment will assign heaven or hell to those who apply, who comply or violate the rules. But I think since I consider that uncontrollable part of the application, by definition, as I just said, uncontrollable, in that sense, there is no legal consequence of misbehavior, of misapplying. And in that sense, in my view, it's more, say, a nudge as a, as you know, nudge is giving a little Yeah, the term is nudge from behind. Yeah, you should do it. You should go in the direction. But if you don't follow, nothing will happen.
Thank you very much, Horacio. Thank you. Thank
Yeah,
you,
it was a
Peter.
very good question. It was a very good question. Yeah.
Peter, maybe what do you think about this idea? If you define these criteria as the nudges, maybe anchoring and adjustment could be, something that could, be the working machine under this, Because anchoring and adjusting, they give you a number, for example, 60 or 70 or something like that,
Yeah.
and then people tend to value, So maybe that could be an idea. But I got the, I don't know. Sometimes I think that these criteria are normative criteria, And you are talking about incentives and procedures, and maybe this is more in the, of course, they have linked, and I think that your work is very plausible, but maybe I think that these criteria are normative criteria that try to include an idea of efficiency, deterrence, well, the probability of an error, the size of an error. Also, they try to lower the cost of errors in judicial decision making. So these two ideas, the idea that maybe anchoring adjustment could be a good idea to think of this, and second, I'm not quite sure if we're not combining normative criteria with description of positive decision making, And finally, I've seen that you mentioned as a special case, because you mentioned that some parts of the legal system have special rules, For example, and you mentioned competition law, and I would be interested in listen what you have to say about competition law.
Well, if you look to competition law, well, it will depend whether you have a 2-tier or a 3-tier system. So in the European competition law, the European Commission decides, you can challenge at the court of, as it was called, court of first instance, and then you can appeal to the European Court of Justice. Right? In Austrian competition law, that would just be a 2-tier system. You have the competition authority that has to go to the court. The court is actually deciding as a panel, decides, and can only be appealed to the Supreme Court. The higher regional court is the first instance, and the second instance is the Supreme Court, and that basically is it. Okay? Now, if you say take a 3-tier system, what is the step from the 2nd tier to the 3rd tier? And this can be explained on law and economics grounds, I think, in a quite straightforward manner. This is just legal control. It's just a question of legal error and no factual control. And if you read decisions by the European Court of Justice, very often so it refers to, okay, the parties bring up this and that argument, but I don't even listen to that because it's a factual argument, and facts are closed in the 2nd instance, so it's just legal control, not factual control. Okay, then let's go one step down. The court of first instance, well, actually knowing that it will not be controlled on factual questions by the European Court of Justice, the court of first instance has the last word on factual questions. And what does it do? Basically, it says gross errors by the Commission in terms of factual misassessment, I will take up. I will take up formal inconsistencies also, but I will not go into details. What I just said is true for the relationship between the Commission and the Court of First Instance in Europe. And even more, there is a subcategory, and this may be the particular spin that you are heading at, in state aid cases that are very complex in the economic assessment. And here, the Court of First Instance, backed by the European Court of Justice, says, okay, basically in terms of economic assessment, I will not second guess the Commission, only if it's really formally in an inconsistent way. So a lot of leeway for the Commission. Of course, the Commission knows this, and the Commission will decide accordingly. Two more things. What does this mean for the parties? I will say, if you are a practicing lawyer, or even an economist advising, helping, assisting the lawyers, you must know where the music plays. So at the last level, no arguments regarding facts. Regarding the Court of First Instance, you must bring up a clear account of an error by the Commission. The best thing is that you bring up an inconsistency, a formal mistake, that if something is relevant, then you should have also considered this and that in the light of what you considered relevant in the first phase. If you just bring up a new factual element, probably you will be unsuccessful. But what does this mean? The battleground is the Commission. You must bring up everything. This is the incentive scheme for the lawyer. This is where you have to go in the infight. This is where you have to bring the economic evidence in the first level. Then it will be, afterwards, it will be extremely difficult and then impossible to bring up, say, new insights. In state aid cases, right, in particular. So that, and perhaps the last thing that I wanted to add in regulation cases, so telecom regulation, so as a sector-specific competition law, that's even reinforced. It's even reinforced the regulatory authorities enjoy in most countries an extreme discretion in applying these relatively soft legal standards, and are, even in the legal sense, not very much controlled by the higher instance, funny enough, on either side of the Atlantic. That would be so my take on that. You don't look too happy, Eduardo. You don't look too happy with my response.
No. I'm thinking, for example, in some cases where the Supreme Court of the United States of the Courts of Appeal of the United States have really made deeply contributions of the structure of antitrust law, and also I'm thinking about Intel case, for example, in the European Commission, no, where basically the court said you have to do all the economic proof again. You have the proof, no? Basically, you have to show. No, well, I'm not going to get into detail. I think that you're in general right, no? Even though I'm not agree completely. No, I follow Horacio in this, that this is a nudge, no? But well, but maybe no. But I'm trying to think in this special area, just as an example, for example, no? And I find that sometimes, for example, I don't know if I have the book here. I have a book of an expert of European Commission law who basically tries to show the impact, no, of the judges on the shaping of UA competition law during the 15 or 20 years. But I don't know. It's a matter of degree, no? It's a matter of degree, and I think your basic point is clear. quite plausible, no?
Yeah, I have a question here by Pedro, whether I believe that the incorporation of trials by jury could positively impact the decision making. Well, actually, for reasons that I have not addressed so much in my presentation, I think actually yes. So in Austria, we have a jury system for some cases. Okay, so what is the idea of the jury system? And very contested in Austria. What is the idea of the jury system? In the continental legal system, the judge is the master of the trial. The judge has a managerial function, meaning that he has the file before him, and he must study the file in order to be able to manage the proceedings. But the more he reads the file, the more he already gets a picture of what's going on, because in the criminal file, all the protocols of the preliminary procedure are, of course, part of. So when the judge has finished his preparation, he has a clear mindset of, so what's going on? And in most cases, he already has a personal conviction of whether the person is innocent or guilty. And confirmation bias is very difficult to shake on that. Now, what is in principle, the genius of the jury system? It is to say, okay, if I have this managerial function of the judge, a role that I call the judge of procedure, it would be a brilliant idea to have a different judge, the judge of decision, a final decision on the merits, if you will, to decide on the case without having read the file before. And you could say, okay, well, okay, let's do this and have a second professional judge to decide. You could do this. You could have one professional judge who's the manager, who's the referee in the proceedings, and you have a separate professional judge who will then decide on the basis of the evidence that is put forward in the trial. But you could also say, okay, well, if we do this system, then let's go one step further and use lay people who are not part of the state institutions to serve as this judge of decision, so be the fourth power, if you will, and that's checks and balance system. People who have not heard about the case before and who just decide not on the basis of the file and the evidence of the preliminary proceedings, but of what has been presented in the courtroom. Wonderful idea. Disadvantage, very expensive system. And in America, there's, in the United States, there is the constitutional right to a jury trial. If you have a jury trial in criminal and civil cases, well, nobody could afford the system. And therefore, because it is so expensive, 95% of the cases are dealt with by plea bargains. This is not the ingenious idea. Well, in Austria, it's a little bit, I would say, a little bit smarter and can be explained on straightforward, if you will, on economics grounds. So when do we use this very expensive system without plea bargains? Well, either when the stakes are very high for the most serious crimes, or if it's not the harshness of the penalty, if these are political crimes, because we may fear in these cases that prosecutors and judges may collude to fight the state enemy. And we need the fourth power here. So we need the independent judiciary to balance that out. And therefore, we have only for a tiny fraction of cases for the very harsh penalties and the severest crimes and the political crimes, the competence of the jury. plus mixed panels where lay people and professional people sit together for the second harshest category. And most cases, 85% of the cases, are decided in the first instance by one single judge. So I think actually that for these reasons, the confirmation bias of the inquisitorial judge in the continental system, the jury system has advantages. It has also disadvantages, but it has advantages. And one thing more, I'm going to say, this as a checking on the same level is also done in Austria. So if the jury comes to a decision, a verdict in either direction, the professional judges, who actually are three, a panel of three professional judges, can set aside the decision by the jury if they think, anonymously think, that the decision is wrong. Not only that they would have come to a different decision, but that the decision is wrong. And then in this case, everything is stopped and the case is assigned to a new jury and will be decided afresh. So because it's difficult to look into the brain of the jurors, of the lay people, it's just if three professional judges concur on the opinion that it is erroneous, this is the reset button, and everything starts afresh. So this is a sort of balancing, because the correct assessment of the burden of proof is very difficult to check on, as I tried to put forward a couple of times already now. Yeah.
Well, thank you very much, Pedro. Thank you very much for asking. Well, is somebody wants to have another question for Professor Lewisch?
I really would encourage constitutional law, but it's not, okay. Would encourage you to think about procedural systems with which you are acquainted. Think, okay, how does the law deal with the control of the standard of proof? And if you ask yourself this question, and we'll say, okay, this is the relevant standard in the highest court, the lower court will decide in the light backward induction of this de facto controllability, what is the leeway that I have? And okay, how will the judge use this discretion? But think about the legal systems that you have in mind, and then you will come, I think that's the contribution of the paper, if there is any, you will see the world in a different light, different to the standard law in economics approach that takes the normative criteria literally.
Would you say, Peter, that is the way that in practice practitioners see the problem?
I would say they should see it in this way.
Okay.
Funny,
okay.
Yeah. Funny enough. What I've presented here, if you actually what I did, if I present this to the former president of the Supreme Court, he would agree fully. He'd say, yes, okay. This is what's going on. If you go to a very experienced defense lawyer or lawyer in a competition case, well, some of the very experienced lawyers really are aware of how the system functions, and that makes them very successful. But some actually have never asked themselves the question of how the system functions. So if you go to so as you know, as I'm also a practicing lawyer, and check many clients and many lawyers don't look to the applicable procedure where they are in an appeals process, and don't think about at the beginning when they start drafting the appeal, okay, what kinds of arguments are allowed? Yeah? But this is really, if in an LLM course here, this is absolutely paramount. Okay, what is the procedure that I am in? What can I legitimately bring forward at what level? And if I know so ex ante, I'm unable to bring forward a certain category of argument at a certain later level, this means bring it forward now, fight now, otherwise it's too late. No?
Yes. Looks like it could be a very practical idea for a practicing lawyer to focus on that aspect, the incentives and procedures.
Yeah, so if I may say, there was a commentary to the criminal procedure in 2 volumes. The first volume is the first instance, and the second is appeals. And so the president of the Supreme Court and I myself have given a couple of seminars together, and our common joke, if you will, was, okay, if the lawyer in the first instance can only take 1 volume with him to the trial, what volume must he take with him? And if you will, the correct answer is the second volume for the appeals thing procedure, because this part will tell him what he cannot bring forward in the appeals procedure. And in the light of that, he must arrange his presentation in the first instance. Right? It's actually applied law and economics, backward induction, but
yes.
Yeah.
Well, Peter, thank you. Thank you so much for being again with us. We
my
really
pleasure and
appreciate
honor.
it.
Really. Yeah.
We really appreciate it. Thank you very much. And thank you, Inés. Very nice to see you. Marcelo, Pedro, Horacio. Thank you very much, Horacio. Well, Laila, thank you. And Luciano, thanks everybody.
Thanks to everybody. Bye-bye. Muchas gracias.
Gracias a vos.
Okay.